And then we'd like to record also this question and answer portion. We just, for the purpose of answering other people's questions as well. And if anyone has a concern about that, please just let us know and we won't do it.
So the first question is from Janet about the injunction and the interlocutory appeal. So the interlocutory appeal was filed by the defendants, and so we are hoping that, well, the interlocutory appeal was something that the courts have already accepted. That's just the request that they'll hear the case. That in this case is the Ninth Circuit Court of Appeals. They've taken it up on interlocutory appeal to determine whether or not Judge Aiken's findings were accurate. And so the injunction is something that we did file, and what that would mean, which I apologize, I should have said exactly what we were asking for with the injunction earlier. What we're asking for the injunction is for all new fossil fuel infrastructure going forward to cease off of public lands and offshore drilling, etc., until this case is heard in trial. And so that was just to kind of move the process forward. So the interlocutory appeal, us winning in court on June 4th would mean that we will go to trial, likely pretty soon. And it would determine when we go to trial, of course. And the injunction would give us the opportunity to not have any further harm be brought on the plaintiffs. So the fossil fuel infrastructure would cease all across the U.S. It wouldn't be any existing fossil fuel infrastructure, but it would be that no new permitting can happen and no new building of fossil fuel infrastructure that hasn't already been established. You know, they haven't already started building it. So it would be pretty sweeping. So that was really to get kind of the fire out, to make the courts perhaps move more quickly on this. So the injunction will be decided probably pretty quickly. That's a really big ask of the courts. So we're not, we don't really know what they'll decide on the injunction, but we are confident about the interlocutory appeal. And of course, both of those decisions in our favor would be very helpful. So Chris asks, what happens next if the hearing is successful? We'll get a trial date, and unfortunately, the defendants, knowing them, will appeal the decision up to the Supreme Court. So we're going to the Supreme Court. Whether or not we win the hearing, we would appeal up to the Supreme Court. This case will be in the Supreme Court again. And people get pretty freaked out by that, but I will remind you that we've been in the Supreme Court a couple times before, and they have continuously said this case needs to go through the proper avenues, channels first before it comes to us. So this case needs to have its trial. It needs to go then to the Ninth Circuit on appeal. Then it needs to come to us if the judges decide this. So the Supreme Court has consistently asked the defendants to the government to respect the judicial process. And then there's a question if we could win the injunction in this hearing on June 4th, or is that just to decide the interlocutory appeal? The June 4th hearing is on the injunction and on the interlocutory appeal. It is a 45-minute hearing. That's really crazy to us that we're going to somehow fit all of that into 45 minutes, but that's what they've given us. So what is likely to happen is that the judges maybe have already made some kind of decision on the injunction and will then present their decision shortly after the hearing. And they just want to get final arguments done on that. I think from what I've heard from our legal team, it sounds like the bulk of the argument is going to be on the interlocutory appeal, because that's really the matters of law that are going to be addressed, the findings that Judge Aiken made. So any other questions? Question from Robin, is there a website that has the explanation and details of the case if we want to refer our faith communities to it to help them understand what is happening with the case now and what might happen next? Yes and no regarding the injunction and interlocutory appeal. We do have press releases that talk about them, but actually something that we've done is we've intentionally not publicized much about the interlocutory appeal or the injunction because it's really, really confusing. Even people with familiar with the court system are not familiar with an interlocutory appeal or an injunction, and so especially not an injunction done favorably. So we have tried to steer clear of any kind of conversation with the public about that. But I am going to put in the chat the link to our press releases. So I would advise people when reaching out to your faith communities, telling them that this is an appeal, a premature appeal before trial, and a favorable court decision for OCT, for the plaintiffs, would be that we can go to trial and a decision on when that would be. Just to keep it pretty basic. And if people ask more questions about it, and of course for your purposes, because I want you guys to know exactly what's going on, you can read the press releases. There's a press release in there that talks about the injunction. That was on February 8th. And so you can read a little bit more on what specifically we asked for in that. And generally asks, if and when you win at the Supreme Court, you mentioned stopping new fossil fuel infrastructure, and would you share more about the plan you want passed? So the stopping new fossil fuel infrastructure in the injunction applies to it's to pressure the Ninth Circuit to make a decision. So once they make a decision and we move forward to trial, that will be lifted. The climate recovery plan is something that we are requesting the government to prepare and implement. However, we will be requesting that top scientists would review that and would oversee it and make sure that it's actually in line with what the scientists are saying we need to do to decarbonize our energy system enough to actually reduce our emissions and keep catastrophic climate change at bay. So the idea is that they would have to prepare it because of the way that the legal system is, and because of it ultimately being their responsibility. We would not have a plan to promote until they said perhaps that they don't have one or that they couldn't create one. Then we would be prepared to step in and say, hey, we have top economists, top policy experts, scientists working for us. They have a plan. So our plan is coming together, but we cannot actually tie it up with a bow and present it until the government would say that they don't have one and that they can't prepare one. And Chris asks, would you agree that the big message for the hearing is that the press sees a huge showing of support by the public, that we do have a right to a stable climate system that supports life, and we want it now? Yes, definitely. That is the big message. Our primary messaging for this rally is that this is urgent, that we cannot wait for more appeals. We cannot wait. We need to secure this right to a stable climate. And people need to know about that, because if you guys think about the flip side, what would it mean for the courts to say that these plaintiffs don't have a right to a stable climate system? That would be really catastrophic. It would really create this constitutional crisis, especially when considering that young people are disproportionately affected by climate change and that the government has caused this crisis. So for us to be denied, for these plaintiffs to be denied the right to a stable climate system, that would be catastrophic, and that would create this constitutional crisis and a lot of conversations about what the state of our country is in. Of course, we are already having those conversations, but it would incite many more conversations about that. So yes, primary message is that we have a stable right to a stable climate system, and that this is urgent. All right, we're going to do one last question, and from Janet, is it right to say that the government has caused this crisis, or that it is not doing what it should, fulfilling its role in addressing it? So our case, so in order to bring a court case, of course, you have to have causation, right? You have to say that the defendant has caused you harm in some way. The plaintiffs have tangible harms from climate change, asthma, increased allergy season or longer allergy season, which affects their asthma, wildfires damaging their homes, flooding damaging their homes, sea level rise. Levi will be displaced from his home in his lifetime. He's the youngest at 11. And so with these harms, we have compiled over 30,000 pages of evidence that our government has known since the 1950s that their actions of expanding fossil fuel infrastructure would directly cause climate change and would disenfranchise and discriminate against youth because they would see the worst effects of climate change, that this would be a cumulative problem, and that therefore the youth would be would face discrimination and would be deprived of their right to life, liberty, and property. So our case is really about government causation, that their actions have directly caused this problem. The U.S. is responsible for 1/4 of cumulative CO2 emissions. So that kind of says it right there, that they knew that their actions caused this, and their actions have caused this crisis, 1/4 of this crisis. And the idea too behind the fossil fuel infrastructure being allowed is that the government is responsible for permitting, tax breaks, and subsidies. So if we're talking about how the fossil fuel infrastructure has perhaps infringed on plaintiffs' rights, our argument is that the government has allowed that and has propped up the fossil fuel industry over 5 decades with that knowledge that they had of its effects. So I think we're going to have to move on now. And if you